Yesterday, we looked at some of the basics of a lawsuit, and if you need to review that video, go ahead and do so. Today, we're going to look at some more complexities of a lawsuit, and let's start with liability. Now, what liability is essentially legal responsibility for harm, um, but you should understand that we have a duty to act in a certain way towards others in society. We have a duty to act with reasonable care towards others. And if we don't act in a way that does that, and it leads to some kind of injury to somebody else, we can be found liable for that. So, liability is when you don't act in a way in which you should, which ends up harming somebody else. For instance, let's say that I have COVID-19. I know I have it. Okay, let's pretend that I know that I'm infected with it. I go out in public and I purposely cough on other people. Okay, I'm not acting reasonably. I'm not showing reasonable care towards others. And let's say that other person that I cough on then comes down with COVID-19 and then they have medical issues because of that. Maybe they even die. I can be liable for their death, okay, because I did not show reasonable care towards others and it ended up harming them. Okay, that's liability, and you can't sue unless you can demonstrate that there is liability. So let's talk about the elements of a lawsuit. Now, if you look in your notes, let me pull that up for a second. You'll see the elements of a lawsuit here, and then there's A and B. In order to sue somebody, there has to be both A and B. A and B essentially shows that there is liability. Doesn't mean you'll necessarily win the lawsuit. You still got to prove your case. But there's the elements to bring up a lawsuit. And sometimes this really doesn't make a whole lot of sense at first, but when we're done with those notes on here, I think it will make sense. So, excuse me. A is the defendant acted in one of the following ways. Okay. So one way a defendant could act is an intentional act, okay, or sometimes referred to as a voluntary act. Let's say that, I don't know, Kenzie is mad at me about her grade that she's getting in this class. So she takes a rock and throws it through the windshield of my car, okay? And yes, I do drive a police car. That's an intentional act. She meant to do what she did. It was voluntary. She intended to do what she did. She intended to throw the rock at my car. She did throw the rock at my car, and she damaged the car. That would be an intentional act. Okay? If you do that and cause injury or harm, then you could be sued. But what if it wasn't intentional? Okay? Let's say that we have a couple people. Let's say Caleb and Avery. And let's say that they are throwing rocks at birds as they fly by. But they're throwing rocks at birds in a parking lot. Now, they're not intending to throw any rocks at cars, they're just trying to hit the birds. But the rocks are coming down, and those rocks are coming down, they're landing on cars and damaging the cars. Okay, it wasn't an intentional act. They didn't mean to damage the cars, but they did it. But their actions was foreseeable. Was it likely that if you throw rocks in a parking lot full of cars, that those rocks might hit those cars, even if you're not intending to? And the answer is yes. You should have seen that this could have happened. That is a foreseeable event, even if it's not intentional. And then a third way that someone could act is in a negligent manner. Negligently sometimes is like, well, the easiest way to explain it is you did something you shouldn't have done, or you didn't do something you should have done. It works either way. Okay, so let's say that there's a red light and you're driving and you see it's a red light, but you drive through this red light anyway and you run into another car. You acted negligently. You didn't do what you should have done. You should have stopped at the red light. You didn't. You ran into somebody else. Their car was damaged. You acted in a negligent manner. There's a number of ways it can be negligent. It's easy to see negligence when you look at crimes. Somebody did something they should not have done. Apologize. Excuse me. But negligently can be too if you were acting in a, not illegally, but you didn't essentially do your job. Okay, so let's say that I'm a doctor and I do a surgery and I leave, a surgical instrument inside the body after I've sewn it up. Okay, I didn't do my job. I acted negligently. Or let's say as a teacher that I give out assignments and I lose all of them. Let's say it's paper pencil assignments and I lose all of your assignments and I give you an F because I've lost them. So your grade, if you were harmed, let's say you didn't graduate, um, because I acted in a way I should not have. I was negligent for losing your assignments. Okay, that would be acting negligently, and negligence and foreseeable sometimes are easily interchanged. Like, is it foreseeable that if you drive through a red light that you might hit somebody? But it's also negligence too. So sometimes that's a little complicated, but nonetheless, if you act in one of these three ways, you might be able to be sued, but there has to be a second element. And that second element is there must be injury or damage. There's no lawsuit if there's no injury or damage. Okay, so let's say that Mackenzie um, throws that rock at my car. She intentionally tries to hit my car, but she misses and she doesn't do any damage to my car. Well, then there's no lawsuit. Even though she acted in an intentional way, she didn't cause any injury or damage. Or let's say that that person drove through that red light, but they didn't hit any cars, nobody was injured or damaged, there's no lawsuit. Okay, so there has to be injury or damage, and that's a key component. Remember when I said it has to have both A or B? Okay, it doesn't have to be all three of A. It doesn't have to be you acted in all three of these ways. It's you acted in one of these three ways and it led to injury or damage. Okay, and then the other thing is the defendant must be the proximate cause of that injury or damage. Okay, and it's pretty simple. If, like, let's say I'm driving a car and I don't stop at a red light and I run into somebody else's car and I injured that, I damaged that car. Okay, so I'm the proximate cause. I'm the person that led to the injury or damage. But sometimes it can stretch further. Okay, let's say that we have a worker at McDonald's, and let's say that he's mopping the floor and he doesn't put out a sign that lets anybody know that the floor is slippery. And let's say a customer comes in and they slipped on the floor and they fall and they break their arm and they go to the doctor. Well, you can say that person's not putting up, failing to put up the sign or some kind of warning that the floor is wet and slippery, it was negligent, and it led to someone getting injured. Okay, so you could sue that McDonald's worker. But who hired that McDonald's worker? Well, the McDonald's corporation or the owner of that store, even though they didn't mop the floor, they're in charge of their employees. So that you could, the person who was injured could sue the store because the store is also the proximate cause of the injury or death. It has to be somebody who you can link it to. You can't just choose somebody who's rich and sue them. But if they are linked or tied to it. So let's say that I'm a bus driver, and let's say that I have some kind of illness that will make me pass out. And I'm driving a bus and I pass out, and we go in the ditch and some kids are injured. All right. Well, obviously I should not have been driving. If I knew I had a condition that would cause me to black out, uh, I'm negligent on driving other people around. But is the school also negligent for hiring me? Was my doctor negligent if the doctor didn't say you cannot drive? You know, was the state of South Dakota negligent if they gave me a bus driver's license even though I knew this, they knew I had this condition? Now, maybe I hid it from them and so on. Maybe I didn't even know I had the condition. So a lot of it comes down to is, did you know and should you have known, and who else knew or who else should have known? Let's say the school didn't know, but should they have done a health check on their drivers before they allowed them to drive? So proximate cause can be stretching that out to other people. And typically we use this term deep pockets. Deep pockets is kind of a slang term used in civil law, meaning who has essentially the most money. Okay, let's go back to that McDonald's one. You could sue the worker at McDonald's who didn't put up the sign, or you could sue the owner of the store. Who has more money, do you suppose? Who has the deepest pockets? And typically, lawsuits will go after the person who is approximate cause with the most money, with the deepest pockets, is what we mean by that term. It comes up quite a bit in civil law. When it comes to minors, a minor can be sued. Someone under the age of 18 can be sued. Typically, you don't, though. Okay, so let's say that someone is 17 years old or 16 years old or whatever, and they are driving a car and they get into an accident and they're at fault. They drive through that red light. They're at fault. They run into somebody else. You could sue that minor, but because they're a minor, you could also choose to sue their parents because the parents are responsible for the actions of the minors. So this person is 16. Who do you suppose has the deeper pockets, the parents or the child? Okay. You can decide just to sue the minor. You could sue again the parents. To prove a case against a minor, you have to show that they should have known that this was wrong. Now, a 16-year-old knows it's wrong to drive through a red light, but if it was, let's say, a 5-year-old who was standing out, let's even make it younger. Let's say a 5-year-old was standing out on the road or on the sidewalk, and they have some rocks, and a car drives by and they throw rocks at the car, and they hit the car, and they cause damage to the car. Well, you could sue that 5-year-old. But what are you going to take? How much money does a 5-year-old have? But secondly, it's harder to win that lawsuit because you got to show that the person should have known that what they were doing was wrong. Now, if it would have been a 15-year-old, certainly a 15-year-old knows it's wrong to throw rocks at cars. Does a 5-year-old? Or was the parent essentially negligent for letting that 5-year-old be out there unsupervised? They're the proximate cause of that, and they probably have the deeper pockets, and the minor may not have known in that circumstance that their actions were wrong. Okay, so minors can be sued, but oftentimes adults are, if they're the parent of that minor. Let's go over one more thing, and that's comparative negligence. Now, comparative negligence is when a plaintiff sues somebody, but they only win a percentage of the money because they are themselves are partly responsible, or multiple defendants have different liabilities or responsibilities in this particular case. And let's try to explain this with an example. Let's say that we have a house party. Let's say this house party, Keith decides to have a house party. And he invites some people to this house party, and he invites a couple people that he knows that in the past have caused a lot of damage in houses, but he invites them anyway because they're his friends. Okay, Paul and Sandy. Well, Paul and Sandy do cause damage to the house. Paul does all the damage, but Sandy egged him on the whole time. So Paul, they had one of those. Let's say they had one of those pools in the outside that are above ground pool. Sandy goes, Paul, why don't you take a knife and slit it? So he does. Sandy says, Paul, why don't you bust all the windows out the house? So he does. And he wrecks electronics and things along those lines. And when it's all said and done, Paul causes $100,000 worth of damage. Okay, so Keith ends up suing both Paul and Sandy for the $100,000 of actual damage to the house. Okay, and let's say that the courts determine that, you know what, Paul is 60% to blame for this. So he has to pay $60,000. And Sandy is 30% to blame. She didn't do anything physically. She didn't break a window or bust out a TV or whatever, but she encouraged Paul to do it. So she is partially to blame. So comparative negligence are saying that Sandy is part to blame and Paul is part to blame, and they have to pay the percentage of what it is their fault. And we see these cases some. Now, if you look at that, that's only 90%. Maybe the courts or the jury determines that, you know what, Keith himself is 10% to blame for this. He hosted a party and invited people over that are known to wreck things at parties. He's somewhat to blame for the injury or damage done to his own house. Now, he doesn't have to pay himself, but if he's 10% to blame, that's 10% of that $100,000 in which he will not collect. And we'll look at some cases where we have some comparative negligence, where we have some multiple parties who are to blame or at fault for, or are liable, I guess, for injury or damages done. Okay, I think we're going to stop there for today, and tomorrow we'll look at this some more.